Hello ladies and gentlemen, this is attorney Shaprali for another video, and today we're going to discuss about adjustment of status and unauthorized employment. That means unlawful employment, and where it becomes a problem if you have taken work unlawfully when you're filing for your adjustment of status. There is a bar which prevents people from adjusting status if they unlawfully work in the United States. However, this bar doesn't apply to cases like spouse of U.S. citizen, immediate relatives, parents of U.S. citizen, VAWA cases, and also certain physicians and their accompanying spouses and children, and certain NATO employees, and certain special immigrant juveniles. This is a law that protects minors when they are abandoned in California, and then also ultimately ends up by giving a green card to the juvenile, and certain members of the armed forces. That means you can basically file for your adjustment of status, and you make sure you of course tell the truth that you work, but it won't be affecting you under section 245A C2 and 245 C8. So you're safe if you are in those categories. Now, many of our cases are employment based. So what happened if you have taken unlawful employment and you're filing an adjustment of status? The rule is governed by INA 245K, where basically if you have not engaged in 180 days, and it's a total of 180 days, that means basically you have to add it all over your life. So if you did 30 days of an unlawful employment today, this year, and next year you do another 30, and your green card takes almost like 5 years. And when you add all this time, you have not passed 180 days, you will still be able to adjust. You get forgiven for that under 245K. But 245K is a defense. It's not something that you can just basically claim as a right to work unlawfully. So remember that it protects you for adjustment of status. And the definition of unauthorized employment means basically that you are working without the permission of the Department of Homeland Security, or ultimately the State Department sometimes. So this is an example they give here. The foreign national left his authorized employment and H-1B in April 2006, and he was not granted H-1B status or EAD or other USCIS employment authorization allowing him to work elsewhere until September 15, 2007. Therefore, the foreign national's employment with the second employer was unauthorized from April 2006 until September 2007. The foreign national is barred from adjusting status based on INA 245 C2 and 245 C8 for unauthorized employment violations. What happens in this case is that that person did almost 1 year of unauthorized employment, and as such that person will not be able to do adjustment of status. So what ultimately that person will have to do is, if they are eligible to do what we call counselor processing, they should be able to do that, but that might trigger other issues if you did unlawful presence, etc. So the issue today is, if you're filing for your adjustment of status, I recommend talking to a lawyer if you have engaged in some unlawful employment. That means basically you were getting paid, taxes were paid, and you were ultimately reporting that, but the truth, you were not allowed to work. So it's something which becomes a big problem. We have seen many cases where people, because of 1 month extra, more than 180 days, that means around 230 days, where they get denied their adjustment of status. But at this point, what do you do? Well, there are some solutions. For one, you might be able, unfortunately, there might not be a waiver for it, but you might be able to wait until your spouse or someone becomes a US citizen, then you file and things like that. But the truth is that make sure you're not engaging yourself in unauthorized employment, especially as soon as an H-1B is cancelled. Even though your 797 says for a longer term, if your employer basically terminates you, the H-1B will be terminated. So at this point, stop working. We recommend that, and avoid getting into any issues of unemployment, because it will become a headache at the end when you reach the time to file for your green card, adjustment of status AOS, which is the I-45. You should be familiar with the rule of 245K and also 245C2 and 245C8 for the exceptions. So exceptions again are for immediate relatives, VAWA cases, and some other cases listed here. So if you have any questions, of course, when it comes to unlawful employment or your H-1B or your adjustment of status, feel free to give us a call at 510-742-5887. Anything I'm telling you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our office again, 510-742-5887. Good luck to all of you. Thank you.